I've been looking forward to all the panels, but I've especially been looking forward to this one because we have some snatched from the headlines issues for this one. Your moderator today is Professor Bobby Chesney of the University of Texas. He's not just a professor of law there, he's the Associate Dean for Academic Affairs. And that is a huge job at this institution. I'm sure it is there as well. He's also one of the founders of the Lawfare blog. Wonder where that name came from. But he also is a very prolific writer. He's a commentator. He is a presence on the Hill. He's a presence in conferences like this. I've had to lasso him about 4 or 5 times before I could finally get him here. And on top of how much he accomplishes, he has a family, and he's a super nice guy. And like I've told Bobby in the past, and he's a nice-looking guy too, except for that beard.
Good thing we wore the ties.
I said, Bobby, there's like a million reasons to hate you. So, but no, really, I'm so glad that
He's also a Mets fan.
Well, a million and one reasons to hate you. I'm sorry. I'll turn it over to you, Bob.
Thank you, Charlie. I just want to say that as someone who really got my start in teaching this subject by sitting in the back of the room as Scott Silman wowed the students at Wake Forest, and I sat there just taking notes and ripping off everything he said for my own teaching. And then later on, Scott was kind enough to include me on the Lens board, and I was on the board for a while, and that was something I was very proud of, and the connection to Judge Everett. Then with the baton passing to Charlie, which is also someone I really look up to, this is a treat for me to be back in North Carolina, and especially to be here at this particular event. So I want to thank you both for what you've done for me. So it's late in the day. We've all been here for quite some time, and just bad news for you. These people are wallflowers. They don't have strong opinions. They don't speak up loudly. But I have given them all liquor, and I have encouraged them to try to speak their minds clearly and loudly. It's possible, as we talked over the issues, it's possible we won't have a huge amount of disagreement amongst ourselves, although I'll do my best to make it seem so.
No, you won't.
Well, yes, I will. I insist upon it. But although we certainly will save time for Q&A at the end, depending on how this is going, I may call for audience joining the issues as we go. We're just going to wait and see. It's going to be a moderated dialogue. Well, I should actually say who these people are, shouldn't I? No. Immediately to my right, this is going to be very brief. The bios are all there. Steve Vladeck, professor at American University's Washington College of Law. Marty Lederman from Georgetown Law, and Andrea Prasso, Senior National Security Counsel at Human Rights Watch. It's some of the people I hold in the highest regard in our field. So, our title is, Do We Need a New AUMF in the Age of Forever War? And I can't resist starting with Marty by asking, Marty, is this the right question to be asking, or is it the wrong question?
It is a right question, but it's, I think, framed incorrectly. And I'm really honored to be invited by Charlie to this panel. It's always wonderful, the whole conference. But I want to take issue with the premise of the entire enterprise. So, but other than that, I'm okay. I want to take issue with the idea that we are in a forever war, which has been sort of the premise of what not only this conference, but most conferences and most public discussions of this issue, of these issues, seem to take for granted. And they take it for granted in the context of the discussions about the AUMF. This idea that we're in a war because Congress authorized this on September 17th, 2001, and that because the AUMF still exists and is still being used as an authorization for military operations, it must mean that we are in the war, the longest war, variously described as, right, in the Bush administration, the global war on terror, or the war against Islamic fundamentalism or Islamic terrorism, or the like. And I think that's really not only wrong just as a technical legal matter to think about it that way, but I think that it distorts the way that we think about the questions, both about what Congress should do, which is going to be a principal topic of our panel, and what the president ought to do, but also about thinking about what the United States is actually doing against whom and in what places. So the AUMF, the 2001 authorization for the use of military forces, most of you know, does not mention war, and it doesn't mention the modern-day equivalent of war or replacement for the notion of war, armed conflict. So it doesn't mention international law concepts that trigger and that govern certain forms of conduct that might be undertaken between belligerents, which has been the subject of most of the panels today. Instead, it authorizes the president to use all necessary and appropriate force, not even military force, but force, against particular enemies, generally understood to mean at least al-Qaeda and the Taliban. Now, whether that force is used in an armed conflict, and I'll use armed conflict because it is the modern international notion rather than war, depends not on the AUMF itself, but on what the United States is doing, what our enemies are doing, what the nature of the hostilities between the belligerents is over time. And it's not one war. So it's at least, at this point, 3 distinct armed conflicts that the United States has been engaged in. The AUMF is the statutory domestic law authority for the president to have been engaged in those armed conflicts. But not only that. So let me just unpack that a little bit. There is the armed conflict that the United States has with the Taliban, or the United States had with the Taliban. It's a little bit unclear whether it ended 2 months ago or not. That's something else we'll be discussing on this panel. Right? We got in, the Taliban was the government of Afghanistan. We clearly went to war and started an international armed conflict with the Taliban in late 2001, which shortly thereafter transformed, in the United States' view and Afghanistan, and the new Afghan government's view, into a non-international armed conflict between the Afghanistan and the United States on the one hand, and some coalition partners, and the Taliban, now a non-governmental entity, on the other, which has continued at least until December 2014, and might be continuing still, but might not. Then there is the armed conflict between the United States and al-Qaeda, which might include al-Qaeda in the Arabian Peninsula or might not. And that conflict began, obviously, at the latest on September 11th, 2001, 6 days before the AUMF was enacted. And according to the government, in some of the military commission's cases, actually commenced at least a year earlier with the Cole bombing, or maybe earlier than that, right? So that armed conflict preceded the AUMF. The AUMF gave the president statutory authority to prosecute it. And there was a conflict against al-Qaeda that I'm fairly certain the United States government would say is continuing to be ongoing, at least in Yemen, against AQAP, whether viewed as part of al-Qaeda or as an associated force or co-belligerent of al-Qaeda. Whether there continues to be an armed conflict against al-Qaeda Central is something that depends on facts that I'm not sufficiently knowledgeable about today. And then the third armed conflict that the United States has begun under the auspices, or at least with the domestic law authorization of the 2001 AUMF, is the more recent armed conflict, no question it is an armed conflict, between Iraq and the United States and other coalitions on the one hand, and ISIL on the other, which has been justified as a domestic law matter, both under the 2001 AUMF and the 2002 authorization to use force against the threat emerging from Iraq, which was the authorization we used against al-Qaeda in Iraq after Saddam fell. So the United States has been engaged in 3 wars against 3 distinct enemies that are not all the same, and none of those are all Islamic terrorists or all Islamic terrorist groups or all terror that's ever been and ever will be. There's been 3 armed conflicts. And those armed conflicts come to an end at some point, which doesn't mean the end of the AUMF authority to take any action at all against those entities. So the AUMF authorizes military force, which might be a different sort of military force once the armed conflict has ended. So the major thing I want to say here is, the more important question is not what Congress and the President do with the AUMF. Most, if not all, force authorizations in U.S. history have never been repealed. They've just sat there and died on the vine, basically. The real question is, what force is necessary and appropriate? Those are the terms of the AUMF. And that, in turn, depends largely in at least 3 areas on whether we are in an armed conflict with a particular belligerent enemy force. The 3 major areas are, and we can get into this. Number one, if you're in an armed, so just to back up a little bit, the Congress, well, not Congress, the President and the courts have construed the AUMF to the words necessary and appropriate to require first that the United States comply with international law in its fighting against these enemies, and second, to understand its authorities to be construed as analogous to the authorities and the traditions of war, the practices that have traditionally been engaged in by belligerents in international armed conflicts by analogy. That's the Hamdi decision. And so deciding whether we are in an armed conflict basically determines largely the scope of the AUMF authority for purposes of domestic law, and it might have effects for international law.
Martin, let me jump in here.
Yeah.
There's a chicken and the egg problem a little bit here, right? If,
Yes.
You know where I'm going with this. How do you handle this idea that the authority is authorized and the authority that can be used is dependent on what's permissible in an IAC under LOAC,
Right.
But no action's been taken yet, and the action, and whether it's an armed conflict to begin with, won't be determined until we actually have activities on the ground. Does this mean that?
Or the enemy's activities against us could be sufficiently intense and of sufficient duration to create an armed conflict before we've lifted a finger. And
what does that mean in the terrorism setting, where the attacks will be episodic and long lapses between them?
So that's a deep question about when an armed conflict persists between one entity like the United States that's engaged in consistent use of military force every day or every week for years on end against an enemy, and an enemy that acts against us only intermittently every once in a while, or might be planning continuous attacks or attacks whenever they could, but only has the capability of attacking in a terrorism sense every once in a while. Now, they put down IEDs, they engage in actions in Afghanistan or in Iraq against the United States on a weekly or daily basis. But the terrorism itself might be quite intermittent, which might be relevant to whether there's an armed conflict. But I just wanted, before I end, just the 3 things that turn on, the 3 major things that turn on whether there's an armed conflict are, 1, can you engage in status-based targeting of the enemy? Can you target them just because they are members of the enemy armed forces? 2, can you try them for violations of the law of war in military commissions in this case, but also under the War Crimes Act? That is to say, is their conduct only a violation of domestic U.S. law or domestic Yemeni law, or also possibly, in some circumstances, a violation of the law of war? Well, that depends on there being an armed conflict. And 3, can you detain them, as we are detaining still 122 individuals at Guantanamo, not for having committed any crimes or any offenses, but simply because they are members of enemy forces, in order to incapacitate them from going back into the battle against us. And what I want to suggest is, with respect to the Taliban and al-Qaeda, although we may still be in an armed conflict with either or both of them, it appears that the Obama administration has basically abandoned 2.5 out of 3 of those war authorities, for the time being anyway. Status-based targeting seems to be either not occurring at all or very rarely. I don't think we've accused any new folks of law of war violations in an awfully long time. And all of our military detention authorities, in Afghanistan in particular and in Iraq, have been ended, and the only military detention issue still remaining is the legacy problem of the 122 Guantanamo detainees.
So let me ask the other panelists to jump in if they heard anything they disagree with. If you didn't have anything you disagreed with, I want to press Marty on one point he just said, but Andrew.
I just want to flag a question, which is whether, so I think Marty has the breakdown exactly right. I think there's a question whether there's a bit of a tail wagging the dog problem insofar as the reason why the government is continuing to claim the need for the statutory domestic U.S. law authority is solely to continue to detain at Guantanamo and not to engage in either status-based targeting or prosecutions of war crimes.
With respect to al-Qaeda Central.
Right, with respect to al-Qaeda Central. So I just want to put that out there.
I do actually disagree with the point on status-based targeting, and I think this ties in closely to what we were discussing in the previous panel, which is transparency or lack thereof. And I don't think that we have enough information to say that there isn't status-based targeting.
Right.
I think, we had the Presidential Policy Directive, which we also have public reports has been, to quote an anonymous U.S. government official, thrown out the window. And certainly other components of it are not being followed. I don't think we have any reason to believe that status-based targeting is not taking place against AQAP, potentially against al-Shabaab and elsewhere.
So I think Andrea's right about that. What we don't know for sure, what the White House said when the president made his May 22nd, 2013 speech at the National Defense University, was that these new rules, which basically foreclose status-based targeting, are the general baseline that will be used outside the Afghan theater. And in December of last year, they seemed to extend that to the Afghan theater. But there's always some suggestion that under certain circumstances, the president himself could authorize deviations from this policy. And Andrea's right. We don't know how often those deviations are taking place, on what justification, or under what circumstances.
To follow up on that, had he said, he definitely mentioned AFPAC, but had he said just AFPAC, or had he said on the battlefield or in combat zones or some formulation like that as exemplified by AFPAC? And if he did phrase it in that more general way where Afghanistan was being cited as the one current example, does that help explain? Because then you can imagine someone deciding, well, Yemen at a certain point also has become, especially if you count the violence between the former government and AQAP, does it become a battlefield too? And of course, Iraq's now a battlefield. Somalia doesn't seem quite as obvious a case, but is what he said amenable to the view that basically almost all the places where we do use force are actually in the battlefield category, so that the narrow policy formulation he articulated actually has almost no application?
No, I think my understanding now is that it applies to putting ISIL aside, a big aside. That with respect to AQ Central and AQAP and the Taliban, the general rule is that the PPG rules, for the lack of a better shorthand, apply. And
PPG for presidential
policy guidance, and that even if there is an armed conflict with al-Qaeda, something I'm pretty confident the United States government would say is continuing, at least in Yemen, it appears that the president has been very eager not to exercise armed conflict sort of authorities, in large measure because many of our allies are very anxious about the idea that there is such an armed conflict, and he thinks that the counterterrorism operations against those entities can be successfully prosecuted without going to the full extreme of armed conflict authorities. But Andrea is right. We don't quite know when, if at all, they are using these sorts of authorities. We know they're not bringing any new military charges or detaining anyone new, but as to status-based targeting, it's a little bit vague.
Well, Bobby, I'm excited to say that we have more disagreement than we thought we would at the outset of this panel, which is that, and this may not be what you intended to say, Marty, but to say that they don't want to use an armed conflict framework or armed conflict targeting, I think is completely incorrect. The president was very, very clear that the policy guidance was purely a policy decision. If you look at, it's a blend of international humanitarian law and international human rights law and other stuff that's sort of made up. It's a very clear statement that IHL, the U.S. government believes IHL applies. It has the legal authority to target under any number of circumstances, but as a matter of policy may elect not to. But when targeting, even if in compliance with the PPG, that would still be an armed conflict targeting.
They certainly think they have the authority as to AQAP, probably as to AQ Central too, because they're still targeting certain Shabaab members who they claim are part of al-Qaeda. So I think you're right, Andrea, but I think the idea is that the armed conflicts as such are probably winding down, and they want to be acting in a way that would be permissible even outside of an armed conflict. I don't know how large the delta is between the rhetoric and the practice.
My point is that the PPG is not permissible outside of an armed conflict. That's really my argument.
Is not
permissible. The rules set forth in that policy guidance are armed conflict rules. They are policy beyond that, but you could not apply that framework to a
Oh, you
human
think the
rights law.
PPG is still even too permissive outside of
Too much for human rights law is what you're
Yes,
saying.
it would be
Okay.
a violation of human rights law to apply that policy and lethally target.
Let's pin that down. Okay, I think this is a really important question because I'm going to come back to this assumption that we're winding down. I'm not sure I share that assumption. I think it may be winding up. But let's assume
both of those mean getting.
yeah, we had this discussion earlier. So let's assume we've got a non-armed conflict context, new group, whatever it is. There's been lots of debate, especially since John Brennan spoke at Harvard a couple of years back and mentioned in the course of explaining the administration's understanding of imminence and what that really required, an imminent threat, that this could be temporarily elongated, that as long as you had a situation where you had some sufficient degree of certainty that the threat was actually a threat to United States lives, was going to happen sooner or later, but you had no realistic expectation that you'd actually know right when the moment came. And then I think this phrase actually originates, I think Mike Schmidt is really where this comes from. Last clear window of opportunity. I'm not sure if that was your precise formulation, but you put that into literature. I think they're picking up on that. And he said, that sounds like a model that, as he described it, Brennan said, this sounds like a permissive model, and maybe it sounds like something that the human rights law community wouldn't accept. But we find in our discussions with our allies that actually we're kind of in the same place and that we have different verbiage, but we end up in roughly the same fact patterns for approval to shoot. I wonder if you agree with the implication that the imminence model, which is the key element or one of the key elements in the presidential policy guidance, is actually a human rights law compatible model.
Well, this is one of the problems when I said it conflates different models of law, because the discussion of imminence in the presidential policy guidance is about armed conflict use of force. Imminence under human rights law is about law enforcement and law enforcement's ability to respond to an imminent threat to life, such as a hostage-taking situation. That's why police can shoot to kill in a hostage-taking situation. It is conceivable that those same principles could apply in some of the places where the U.S. does use lethal force. I'm not saying it does, but there could be a law enforcement type scenario. Somalia maybe is the best example in areas where there really is no state action. There's no reach of law enforcement. So that is it possible for, say, a U.S. drone to be performing a law enforcement function at the request of the Somali government to prevent the imminent loss of civilian life? That is theoretically possible. That is not the argument that the U.S. government has ever put forward. When it talks about imminence, it's talking about the other types of imminence that we heard the previous panel talk about, imminent threat of armed attack, the state's authority to engage in self-defense. Although I will say I think there's a very good reason why the PPG blends some of these models. It's not a deliberate attempt to obfuscate, but it's an attempt to say some people believe there are gaps in the law. Let's draw on different parts of law to come up with something that works. And of course, Human Rights Watch position has long been where there are gaps, you follow the law that you have. You don't make new law. And I think that's sort of the last 13 years of tension we've had in the post 9/11 era. Are there gaps in the law? If so, the U.S. government has said, well, we operate by analogy. These people are not POWs, but we can detain them for the duration of the armed conflict. Other people say there is no affirmative authority to detain in a non-international armed conflict, therefore you look to human rights law. And that's sort of the fundamental divide we've seen in the past 13 years.
And it's not a coincidence that the places where we've seen the imminence argument deployed, at least the most overtly, are parts of the world like Somalia, where there's reason to doubt the efficacy and ability of the local government to even do any ordinary law enforcement. And that it's not at all clear that the U.S. would take the same position, the language of the PPG notwithstanding, if the exact same fact pattern were presented in northern Yemen versus Paris, where obviously there is and are local authorities in a position to effectuate a lawful arrest.
So I think what all three of you have put your finger on correctly is what I think of as sort of the tyranny of the imminence discussion, because the U.S. government has not been, imminence comes in as a question into about at least 5 or 6 different legal questions. Some of them are domestic law questions. They might be involved dealing with domestic statutes. Oftentimes imminence is used as part of the calculation deciding what the president can do on his own as opposed to without statutory authority for purposes of U.S. constitutional law. And in international law, imminence, as Andrea points out, is relevant in at least 2 distinct respects. One is the question of there needs to be some level of imminence or necessity in particular in order to breach the sovereignty and use force on the land, on another nation's territory, an ad bellum question under the Charter in Article 51. And the other is that international human rights law, including customary international human rights law, even though the U.S. might resist the application of the covenant, it would agree that customary international law applies. And imminence obviously has, it may be a different notion of imminence, as Andrea is suggesting, than the ad bellum imminence, comes into play in deciding when you can use force, even against not status-based force, but a threat-based force, when you have to wait. How long do you have to wait to see whether there's other means of interdicting the threat before you use force? And the U.S. has not been express about which of these 5 or 6 different legal relevances of imminence it is invoking, although my sense is that they would argue, if pushed, that they are only using force in these cases, the non-status-based force, where it would satisfy both the Charter and international human rights law. Now, they would get a lot of blowback on this, at least the second one, about whether it does, in fact, satisfy human rights law, but I think they do believe that.
But the tyranny of imminence point is really important because it's not just that there's this debate that may seem very technical to those of you who haven't spent a lot of time thinking about it over the different sort of ways imminence shows up. It's that this is where the ballgame is, as contrasted with a broader discussion of who are we at war with and where. Right, the reality on the ground is that the U.S. uses of force at the moment are not nearly as broad as the existing authorities would allow. Right, contrast that with, for example, World War II, where the U.S. was using just about every kind of force you could think of, and some you couldn't think of. Right, here it is much more calibrated, and I think one of the hard questions is, does that change the legal discussion about the statutes, about the domestic international law authority?
I think it hugely does, because what we're seeing here is that a lot of the reality of how we make decisions about who can be attacked and in what circumstances, right now it's being driven by policy constraint, or it's being dominated by policy constraints that are within the boundaries of what would otherwise be broader authority. And the looming question with an election on the horizon is, in some respects, are the current policy constraints in some fashion going to be hardwired in a way that will potentially box in the next president, who may well come into office and say, this PPG, very interesting. All right, we have an armed conflict with al-Qaeda. Where are they? And let's use the maximum extent of our authorities, not some subsidiary extent.
I agree, Bobby, except that the existence of the PPG, yes, if it's a Dick Cheney who comes in, they're going to toss it over your shoulder, although you won't be in the room.
They'll toss Bobby over there.
They'll toss Bobby over their shoulder. You won't be in the room.
Bobby.
But generally speaking, it does create quite a severe burden on the next administration to justify going beyond what this administration was doing institutionally. And in particular, the important point was the last one you made, and that's what I'm trying to stress. You'd have to find, in order to even be able to legally do that under the AUMFs, you would have to find and have a factual predicate to support the idea that we are, in fact, in an armed conflict with that group that we want to use the broader authority.
This is my chicken and the egg point. So take al-Shabaab. So there's a premise that Marty and I have talked about previously that I want to make sure we're all on the same page on. Al-Shabaab comes up as an indigenous organization in Somalia, like-minded to al-Qaeda, but not formed as an al-Qaeda cell. But over time, lots of al-Qaeda overtures. Eventually, after some leadership tussles, the currently prevailing leadership decides to formally embrace the idea of being an al-Qaeda franchise. Not clear what kind of direction and control really falls from that, but there's the formal connection. So al-Shabaab becomes, in Somalia, an al-Qaeda franchise. Does that make them an associated force engaged in hostilities against the United States? It sounds like the administration has not crossed that line. And instead, when we have had uses of lethal force in Somalia, it's been because the particular person targeted was tied in some distinct fashion to al-Qaeda and in some operational way. At least that's what I think.
That's their position.
That's their position. That seems consistent with the public record. New president comes in and says, all right, I'm not interested in these policy constraints. They're over there somewhere. Al-Shabaab. I want to go after al-Shabaab using status-based targeting, full-on armed conflict authorities, make the maximum use out of them. And Marty, you were just saying, this depends on whether you actually have armed conflict. The chicken and the egg element is, well, if the president says, all right, begin a substantial air campaign, it's going to be an armed conflict, and there has to be some place where you can start it, as long as you're within the rules of the UN Charter,
but if you
right?
take the charter seriously, you can't just willy-nilly, without at least a self-defense rationale, start a huge campaign against
Mogadishu, the government there encourages us to please do this.
So this gets to what I think is the most important question coming out of the last panel. The thing that international law really needs to develop to deal with is the anxiety, and someone up there asked a question about it. The gap seems to me to be the cases in which, at least potentially, the host nation offers you consent to come into their land to strike against non-state actors. You've thereby satisfied the charter.
Yeah.
And there are no further constraints that would apply. That is Ashley Deeks.
This is Yemen and AQAP. And
Well, except that we do think that there's that AQAP is attacking us and attacking the Yemeni government with regularity and intensity and duration. So it doesn't quite get to this point. But I agree. This is the looming concern is this scenario. Ashley Deeks has
Let's make it Boko. We can make it Boko Haram in Nigeria. Nigeria's been asking for. Well, we don't know what they're asking privately. We're hearing what they're asking publicly. We're not interested yet, but I'm just hypothesizing a more aggressive posture by a future president. The armed conflict model, in short, I think actually has a lot of legs left in it if the right person is in office wanting to take full advantage of that.
And determines in a secret, non-publicized, non-reviewable finding that Boko Haram is increasingly aligned with al-Qaeda and participating as effectively a co-belligerent in hostilities against the U.S. or its coalition partners, which, oh, by the way, could include the government of Nigeria. So
Is
the circle.
there any reason we should have a different view towards Boko Haram than we do towards ISIL?
well, I think what we're doing is we're mingling the domestic and international law issues here, and I think it's really important to separate them out. Can the U.S. start a war against Boko Haram in Nigeria? Sure. You can deal with these antebellum issues. There are major domestic legal issues. Once it does that, however, IHL is triggered, and the only question is, are the parties complying with IHL? And then we have the domestic issues, the AUMF, which we probably aren't going to talk about that much.
No, I think we're getting close to it now. We're zeroing in on
Premise
it.
of our panel, which is what does the U.S. Congress have to do under domestic law, and then the interaction, if any, between that and the international.
But one of the things I'm trying to suggest is that I think some of the deep uncertainty that is pervading the debate that's happening in Washington right now about the ISIL AUMF is a symptom of this disease, which is to say there are 11 different conversations happening about 3 different sets of authority against 8 different groups. It's actually probably 24 different conversations, right? But right, which is to say that there's so many. It's such a large matrix, and the government is in a position to take advantage of so many different boxes in that matrix. And so the question is, how, as lawyers, do we actually fashion a meaningful way of describing the matrix and the different consequences of being in this box versus that one, both as a domestic law matter and as an international matter? I think part of what we're seeing is why that's been so complex already, even before we bring in ISIL and the scope of domestic law.
And this gets at something else from the last panel. One reason it's complex, it's one thing for us lawyers outside to be describing what we think, which boxes we think the U.S. is playing in right now and has the authority to play in under international law. But I think, given that I don't think Congress is going to, let's put it this way, I don't think Congress is going to do anything with the 2001 AUMF, whether the president wants it or not. I think what's really imperative, or would be very valuable, is before he leaves office for President Obama to describe in more granular detail which boxes where he thinks we're in an armed conflict and which authorities are legally, not necessarily prohibited, but which authorities we're using and why it's compliant with international
Another
law.
speech.
No, a speech that describes the framework that actually exists within the federal government, but that is not publicly shared very often.
And you think this might have some constraining effect on the next administration?
Very much so.
Well, I think that depends on who the next administration is.
I'm not sure if it does.
I think it does. I think politically it would. I think especially because it would be a lot of the same people if it's one administration versus if it's not.
It could have the opposite effect if it's a change to the Republicans, in fact, right?
Yeah, so
It could.
if it's narrow and a Republican would like it to be broader or be interpreted as broader.
But by all accounts, the president internally is trying to set up protocols, understandings, legal theories that will be binding beyond the term of his administration in a practical manner.
What you just said, I think, is really important. I think that that's absolutely right, and I don't think it's part of the public narrative. I mean, I think it's the case that the Obama administration is trying to figure out, not just in this sphere, but in a lot of different spheres, in the time left in office, how to entrench a variety of positions, as any president does towards the end of their time. Some of it's about appointments, but in this case, it's trying to entrench the hybrid rules of the road that they've developed over time. And by the way, some of this also developed in the Bush administration. It's not just a new project. This has been the project of the past 3 presidential terms. But I'm very curious, you mentioned a speech to the public as one way just to sort of, I guess, flag for people, look, this is where we are. What else can be done? I mean, obviously executive orders can be issued, but those are going to, they're going to go right on top of that pile back there.
I think you underestimate how sticky executive orders and internal protocols are. I think you establish an entire edifice, a structure of bureaucratic buy-in to those things. It becomes very difficult.
True, but that's the trick, right? And the CIA is a great example. Director Brennan is trying to undertake a substantial reorganization. When he first went over to Langley, there was a lot of talk about how CIA is going to get out of the kinetic operations business. That's not happening. It's not because...
That's what I mean. They're entrenched
Well,
bureaucratic protocols.
and my point is, he's going to have if he could change the bureaucracy, entrench the culture, and get all the people up and down the bureaucracy in place to really embrace the agenda, that will have a lasting impact. I don't think there's enough time left on the clock for him to get anywhere near accomplishing that.
At the risk of disagreeing with Marty, which I'm usually
It's your
loath to
job
do.
here today.
It's your job.
So color me as someone who is not convinced that working hard behind the scenes is sufficient, even if it's necessary. And what do I mean by that? Well, so part of the story that I think is not being told about what's happening in Washington right now is not just that the Obama administration is lukewarm on the question of whether an ISIL-specific statute should address the 2001 AUMF. It's that they are affirmatively campaigning behind the scenes to prevent that from happening. And that's not... that is not entrenching into internal structures, some kind of narrower view of things. That's actually getting in the way of Congress, perhaps, recklessly trying to do something.
So I'll try to recharacterize it. I think the president genuinely would want a much more tailored 2001 AUMF. He knows that will never be done. And what he is trying, I don't know what's going on behind the scenes in terms of campaigning, but I assume that what it is urging, he wants a bipartisan bill with respect to the ISIL authorization.
And there's
he's urging Democratic members of Congress not to jump off the ship because they won't get some change in the 2001 AUMF.
But there's a difference. So the specific issue that's being debated is whether a specific ISIL statute should, in addition to sunsetting itself, also include a sunset for the 2001 AUMF, not to expire that statute, but to import the same democratic accountability principle that Congress should, on a regular basis, be revisiting whether this authority is still necessary, and if so, to what extent. What it sounds like from 7 or 8 different Democratic offices, the Obama administration is telling Democratic staffers is they don't want the sunset. I don't know how the sunset, which is also, by the way, supported by a surprising number of Republicans, is antithetical to the bill's passage.
I'm just not sure that's true, that they don't want it. I don't think they think it'll happen, and therefore they don't want it to complicate the legislative debate.
I take it you all support the sunset. So let's quickly pivot over to the ISIL.
It's only 3:30, so
we're gonna,
a couple of hours.
We're going to come back to this again, this other stuff, but the ISIL-specific sunset legislation sunset, the draft says expires in 3 years. Not that it can't be renewed, but there will have to be revisited in 3 years. Do you all support the idea of a sunset? And if so, is 3 years the right term?
I support the idea of a sunset because AUMFs concern me. And when you look at the range of civil rights and human rights abuses that Dean Chemerinsky so eloquently detailed for us earlier today, all of those were conducted at least in part based on at least purported authority pursuant to the 2001 AUMF. Surveillance changed over time, but at the outset it was pursuant to the 2001 AUMF. Unlawful targeting, unlawful detention, torture, and so on. So AUMFs concern me a lot. Limiting them, I think, is a good thing.
I'll just say it's worth remembering that the Constitution itself imposes a sunset on military force. It requires reappropriation of military budgets every 2 years. So there already is a constitutionally mandated sunset for at least some military force. We haven't really followed that because defense spending has become, well, a panel and conference unto itself. But so I think sunsets make a lot of sense in the use of force context, especially because of their counter inertia effects. I actually think 2 years makes more sense because then you're tying it to elections. And so each successive election could become a referendum on the.
Which way does that cut?
It cuts in favor of, we get the government we deserve, right? And better the crazy people we put in Congress in 2015 deciding whether we should continue the AUMF than being beholden to the people who were reacting to 9/11 on September 14, 2001 while Ground Zero was still on fire.
Which raises the question, I keep hearing talk about refining the 01 AUMF. If it's not being entirely repealed but just being refined, what is it exactly that any of you want to see added into it that's not already there, locked in through judicial holdings or other legislation?
Well, I'll jump on that grenade. So among other things, I would like reporting requirements on exactly who the administration believes the AUMF applies to, and at least, if not for public reporting, then for reporting to Congress exactly where force is being used.
You mean at the organizational level, who are the associated forces?
We keep talking about the boxes and the matrix, right? I think Congress is entitled to know the full matrix, even if there are security reasons why maybe the full matrix shouldn't be disclosed to the American people.
They do know that now, but it would be good to put that in a statute, sure.
Should the public know?
Bag and stomp their feet.
Right, it took forever.
Should the public know? Should it be very clear to the public at any given time, at least maybe with a little bit of lag time, if some new group has emerged, if Ansar al-Sharia in Libya is determined to be an al-Qaeda associated force, should there be a mechanism where the public finds this out through maybe a WPR letter or something like that?
I think so, and not as a member of Human Rights Watch or a lawyer, but as an American citizen.
I'm going to look to the audience here. Does anyone object to the idea that the public, I'll just assume your silence equals acceptance. Does anyone object to the idea that we should actually have that associated force identification within some certain amount of time to take account of perhaps operational surprise advantages, eventually made known to the public on a regular rolling basis?
I think that's sort of what we have now, but the exception, and this gets to the transparency question.
How is that what we have now? When was
What
the
we
last
have now
time the
is
Obama
the-
administration publicly reported to the American people who it believes
Last summer when Steve Preston testified before the Senate.
when the General Counsel of the Defense Department testified at a hearing that no one paid attention to who's not in this room.
And prior to that, you had to read a footnote in a filing.
Wait, I blogged it. You all read it, right?
There you go.
We've been telling Marty he needs to get on Twitter, and if only he were on Twitter, then we'd all-
Marty, I adore you and your work, but I really doubt that the vast majority of the American people read Just Security.
Okay, fine. The only group against which
Because they read lawfare.
right? Oh, now fighting words. Okay, so
I'm torn.
yes, of course. There's one big exception, and it gets to an issue from the last panel, which is what are the reasons why, in certain times and in certain circumstances, the United States, like other nations, refuses to acknowledge that it's using force in a particular nation at all. And that happens from time to time. And one of the principal reasons for it is that such non-acknowledgement is a condition of getting not only the consent, but the cooperation of the host nation in that activity. And that's a huge problem for transparency, and I agree with, I guess it was Jens and others on the last panel, that has a long-term, very detrimental effect on the development of the law of war and on the world's understandings of the law of war when a nation cannot even acknowledge that it's using force in another nation, and therefore obviously can't get into any details at all about the granularity of how it's using force, why it thinks it's complying with the rules of proportionality and necessity and distinction and the like, is a huge problem. And along with the consent issue, that phenomenon, the phenomenon of nations insisting upon non-acknowledgement as a condition of consent and cooperation, is something that I think international law needs to contend with over the next 10 to 20 years.
I think this transparency issue is really important, and you asked before how could things be more transparent, and Marty said the president could give another speech, which would increase transparency. But, you know, when you asked the question earlier, Bobby, about what exactly did the president say about where the PPG would apply, it was outside the active theater of hostilities, I believe. But in order to know that, you had to not only listen to the speech and read all of it, you had to read the fact sheet that the White House put out, you had to read the readout of the private conference call with reporters that took place immediately prior to the speech.
All of which was unjust security.
And then read the subsequent reporting where reporters went and did follow-up questions with White House spokespeople and got clarification. That is not transparent. That is not going to a website and reading, as we can now, where has the U.S. and its allies engaged in lethal force in Iraq and Syria.
So should we have like a DFTO type list?
That's where I was just going, right? So I don't think the FTO list is a dangerous analogy for reasons I can elaborate on.
Someone's told me that before.
But no, I mean the FTO list.
Did you guys know this is the foreign
not to
terrorist?
explain.
Oh, sorry.
So under federal immigration law and under the State Department's controlling statutes, the State Department has the power to designate certain terrorist organizations as what are called FTOs, foreign terrorist organizations, under 8 U.S.C. 1189. And the consequence of being designated as an FTO is that you become toxic. It becomes illegal under the Material Support Statute 2339B, which Erwin talked about at lunch, to provide material support to such an organization, which includes providing yourself to such organization. The Treasury Department gains all of these authorities to freeze their assets, and so on and so forth. The key, though, is there must be a process pursuant to which the designation of the group is publicized, is open to challenge under the Administrative Procedures Act, and indeed perhaps is collaterally available for attack in a criminal prosecution. So contrast that publicity, which, by the way, includes the publication in the Federal Register of every group the State Department determines to be an FTO, with what you're hearing from Andrea about what transparency looks like in the Associated Forces context.
So this little round began with the question of, if the 01 AUMF is revisited, what is it exactly that the president wants or that any of you might want? So one thing on the table is better transparency about who the groups that are covered might be, and I endorse that. Give me some more. Maybe I'll jump on the bandwagon. Or is that all y'all wanted?
I think as long as the political branches both believe we should continue to engage in some military action, even if not status-based targeting, against al-Qaeda or AQAP, that it's better to have a statutory basis for that rather than to rely upon simply constitutional authority.
I would say, while it is true that international law governs all U.S. conduct in these situations, it never hurts to write it down. And having a clear statement that IHL in particular governs if there is an armed conflict and the international human rights law is applicable at the same time as well as otherwise, I think would be quite helpful. We haven't really talked about detention, and in my view, of course, detention would flow from those international legal authorities, but whether that is the U.S. government view or not, I think that articulating it in an AUMF would probably make sense. If you were going to build this from whole cloth, wouldn't you want some sort of clarification? Right now, as we understand it, there's no U.S. detention in the conflict against ISIL. That may not always be the case.
Right. Yesterday I was on the Hill arguing that you need to decide one way or the other on detention, but don't just ignore it as if this doesn't exist while you're authorizing force to kill people.
Especially because, I mean, one of the things that we've learned from the last 10 years, it's still an open question whether and to what extent even the 2001 AUMF authorizes the detention of a U.S. citizen captured not in Afghanistan. And so if that were to arise in the ISIL context, which, by the way, is not that hard to envision how that might arise, that's going to be a whole mess of litigation before we ever get anywhere.
Do you think there's in light of the National Defense Authorization Act, which is actually the controlling statutory authority for detention now, it's hooked back into
most cases.
In most cases, yeah. Is there an issue? So we talked earlier about the ostensible drawdown and the rhetoric of war ending in Afghanistan, when in fact actually it looks a lot like it has in many respects. The volume of U.S. troop presence is smaller, but it's not going to get that much smaller, we are told bit by bit in recent days. But as you all know, there's a motion in play with one of the Guantanamo detainees saying that the president's declared that combat operations in Afghanistan are over. We're now moving into this wind-up phase, and therefore the armed conflict-based authority to detain me has expired because the conflict expired. So when do I leave? Do you agree we're at that stage yet? What would it take to actually get to that stage?
So I think if I can go back to Marty's point earlier about how we're in 3 different armed conflicts, I think it's
We were.
Yeah, and this is a Taliban detainee who made the
no,
argument.
that's where I'm going, or were, right? So the key to understanding this case, which is called I can't pronounce his name, Warafi, W-A-R-A-F-I. I don't know why I had just anyway. So is that he is a Taliban detainee. He is not alleged to be or found by a CSRT to have been affiliated with Al Qaeda, and so that's why the December stuff that happened with regard to the withdrawal in Afghanistan, President Obama's statement that combat operations in Afghanistan have ended are now being invoked in this renewed habeas litigation. I don't know that we're there yet because I don't know that the second the war is over, you get the end of detention. I think there's some support for the notion of some limited wind-down detention authority. The problem is there's no law on the subject of how long that is or who decides that question.
But have we even triggered the stage where you're now at wind-down phase, where the clock is ticking in some sense?
So here's
or is
the
it still armed conflict? Because we may not call it that, but the Taliban's still out there.
So the last thing the Supreme Court said on the subject was in 1948, in a case called Ludecky versus Watkins, which was about German nationals held under the auspices of the Alien Enemy Act of 1798. And if you think about this for a second, the timing makes sense. You have these German nationals who are still being held in basically administrative detention in 1948 because of their fealty to Nazi Germany, a country that had not existed for 3 years by that point. And they go to court and say, hey, you can't hold us anymore, government. And the Supreme Court, in a 5-4 opinion by Justice Frankfurter, says the war is not over. This is when I teach this in my class. It's the Animal House line. Nothing is over until we say it is, right? So the Supreme Court says nothing is over until the president or Congress says it is. And with regard to the war in Germany, that wasn't over until October 19th, 1951. So the real question is whether the president's statements in December are going to be treated by the courts the same way that the courts treated President Truman's declaration that the war with Germany ended in October 1951, or Congress's subsequent proclamation that agreeing with him, or whether a speech is in fact not enough to communicate enforceable legal
And of
power.
course, from my point of view, I would say we are not there yet because we were never there, because there never was the legal authority to detain people in this context. Having said that, if there is an armed conflict, I don't think that the declaration that there are no longer combat troops present, which is perhaps not true anyway, means anything legally.
Details.
Anyway, I think it was illegal to start, but if there were lawful detention, that declaration, I think, is largely irrelevant, at least right now.
Well, he also said that the longest war in American history is coming to a responsible conclusion.
One day.
Well, earlier in 2014, he had said it will end by the end of 2014. At the end of 2014, he said it is coming to a responsible conclusion. He didn't say which war. I assume that what he's referring. No, I assume that what he's referring to.
The war on drugs in Colorado.
That is true.
Is the war against the Taliban.
Sure.
And if I had to predict, I'd say that it's doubtful that this will come to a head in the habeas litigation for one of two reasons. That is to say, the government will not have to take a position one way or the other on whether the war with the Taliban continues. Because they will either transfer Warafi, he's been on the transfer list, he's been approved for transfer for years and is not dangerous, and they'll just accelerate their efforts to transfer him. And I doubt, my understanding, someone in the room may know more than I, is that apart from him, there are either 0 or fewer than 5 Taliban detainees remaining at Guantanamo, and they're eager to make sure that number gets down to 0 quickly. So the issue will really be raised when the al-Qaeda detainees start making the same motions, and the government will obviously say the armed conflict with al-Qaeda is not over, largely because of what's going on in Yemen. And at that point, it'll be interesting to see what, if any, federal judge is willing to press the government to make the case under international law that the armed conflict continues.
So let me just say, there's at least one who I suspect is interested in this question, and is a federal judge. And his name is Justice Breyer. Right, so there's a curious there's a curious concurrence in the denial of cert in a Guantanamo case from last summer called Hussein versus Obama, where Justice Breyer wrote an opinion basically noting how there are two fairly fundamental questions about the scope of the government's detention authority that have still not been resolved by the Supreme Court. He was very careful to say the lower courts have handled these questions and we haven't, to which I say, well, what's stopping you, Justice Breyer? And his response, 3 more votes. But the 2 questions he flagged, I think, are both really relevant to this exact issue. The first was whether the AUMF authorizes the detention of individuals picked up outside of Afghanistan. And the second was whether it authorizes detention for a potentially indefinite period. That is to say, without any temporal limit other than the ongoing state of hostilities. And he says those are both open questions that in an appropriate future case, we ought to consider. So that's not to say he's going to resolve them against the government, but just that he at least is already paying attention.
I do want to put this before, if you want to move on from detention, but before we do, I do want to put it in perspective because I think we've all almost taken for granted the status quo and how different it is from the detention practices of the United States 5 or 10 years ago. So when President Obama came into office, and there were basically 4 or 5 serious detention questions that needed resolving. One was, as Steve mentioned, the detention of people who are apprehended in the United States. Another was the detention of U.S. persons overseas. Another was just general detention of people outside of Afghanistan. And in all 3 of those areas, the president basically took steps to make sure that none of that would happen, and none of it has. The 4th would be the detention of persons captured in Afghanistan. And the most unreported huge news of the last few months in this area. In December, the United States sort of quietly in a press release said, our detention practices in Afghanistan are hereby over. Whereas like 3 months previously, there had been 50 guys that we were holding that we didn't know what to do with. All of a sudden, they're not in our detention. They're not in our custody anymore, and no one's quite explained where they are. But we've ended all military detention operations in all of these areas except the lingering Guantanamo problem, the legacy problem, that is largely a function of mistakes made at the outset without a theory of what to do with these guys at the end. And President Obama has tried to get that population down closer to 4 or 5 dozen. I hope he's able to do so, but then we will continue to have this problem of the last few dozen detainees.
If I could just quickly, I want to link the new ISIL AUMF with this issue, which is, Marty said there's litigation, someone who says, well, I'm detained as a member of al-Qaeda, but the war with al-Qaeda has ended. And that person would be, under U.S. law, detained pursuant to the 2001 AUMF. I think it's a very interesting question if there's a new AUMF against ISIL. And if that is the primary conflict, what does it mean when the U.S. government may try to defend detention pursuant to the 2001 AUMF? Obviously, if somehow Congress gets rid of the 2001 AUMF, that will solve the problem. But assuming it's ongoing, and yet the administration has sought and obtained a new AUMF against ISIL, which it claimed it didn't even need because the 2001 AUMF applied, I think there's some really interesting questions there about whether the 2001 AUMF even still exists at that point or is sufficient to authorize the detention of someone.
And just to maybe close the loop on detention, I also think it's worth stressing a point that hopefully is clear by this point. I think Marty's absolutely right that detention is a legacy problem for the moment, depending on what happens going forward with ISIL, at least for the moment, at least right now. And that the real question is, what do you do about the 122 guys still at Guantanamo? I don't think it's possible to overstate how important that question is to the whole AUMF debate. At least the legacy problem, at least in Washington, which is to say, if there were no Guantanamo detainees, or if there was a separate statute that authorized their detention, I think you'd be hearing a lot more discussion of repealing the AUMF from the 2001 AUMF, or at least dramatically revising it from both political parties. And I think the elephant in the room, the third rail, whatever metaphor you want, the thing nobody wants to touch.
The tail wagging the dog.
All of them. I said that one already. Right? Is how any amendments, any alterations, any revision to the 2001 AUMF affects those 122 cases. And I think that is an inescapable fact and an entirely disappointing reality that can be fixed. Right? That we're smart enough to have 2 conversations at once.
I'm not sure.
A broader question. Steve wants to write a domestic law detention authority for the last handful of last few dozen Guantanamo detainees, which is a very delicate project.
Well, look, you guys are talking about this like it's just a legacy problem. That's all it's ever going to be. Al-Qaeda's still out there. We are in the midst of a 2-term presidency where new military detention outside of Afghanistan isn't an option. So it seems like this issue is sailed and it's just a legacy issue.
Bobby, it's important to clarify, military detention.
Yeah.
So what the administration has done quite successfully, and yesterday there was another big conviction, is work with coalition partners and the host states to detain them under the laws of those states for some time, and then to build criminal cases against them in the United States.
No question, but is that, so from a human rights perspective, is that really better? So right now, it's not like no one from ISIL is getting captured. There are some, and they're going into Iraqi custody. And we don't touch them. We're not going to touch them with a 10-foot pole. But don't read anything into that. We're not going to. That sounds bad. We're not going to get involved in the detention in a direct way. Is this really the human rights optimal outcome?
Right. So you raise a really important question, which is not looked at very closely right now, but I think is incredibly important, which is proxy detention. Now, in the armed conflict against ISIL, proxy detention is not really the right word. It's, if the Iraqi forces detain...
Post-nation detention.
Sure.
They're the ones who's
and if the Iraqi forces abuse their prisoners or violate human rights, then there's a human rights problem there. Right. Separate, however, is in other countries, in Somalia, in any of 100+ countries, whether those nations are detaining people at the request of, at the behest of, with the assistance of, for the possibility of obtaining intelligence for the United States government. And that is I think, probably relatively minor problem now, but one that will expand significantly over time.
And there's a small amount of case law, right, on this problem in the U.S. courts. There's a doctrine called constructive custody, which was used in at least one case in 2004, albeit a case of a U.S. citizen.
Not very successfully.
Well, it depends on how you measure success. I mean, so the Abu Ali case, there was a U.S. citizen who was picked up by the Saudi government, who was interrogated by Saudi intelligence officers, certainly at least with FBI officers in the room. Whether they were controlling the interrogation or not, I think remains a disputed factual question. Abu Ali brought a habeas petition or I should say his parents, who just so happened worked at the Saudi embassy in Washington, brought a habeas petition on his behalf. Judge Bates, not exactly a bleeding heart, pro-detainee judge, held that the allegations were sufficient to support a claim that the U.S. was involved in that proxy detention and ordered discovery. 3 weeks later, magically, Abu Ali showed up in a courtroom in Virginia, thereby mooting the habeas petition and vindicating it all at the same time.
But in his criminal case, the allegations that the FBI was directing or involved in coercive interrogations were basically thrown out, and coercive interrogations were admitted against him.
Well, right. It was held that the interrogations by the Saudi intelligence officials were not a joint venture for purposes of Miranda doctrine. Now, don't get me wrong. I'm with Andrew on this. There's a lot of play in the joints that I think the government could take advantage of and shouldn't be able to take advantage of. My point is just that if we get that far, I think there's at least some jurisdictional ability.
But that's if there's a U.S. citizen who ends up inside the U.S. I mean, the greater problem is going to be people detained for a limited period of time who no one ever hears about.
That's right. Okay, so I'd love to go further. I'll simply end by saying that I certainly don't think we've seen the last of military detention of al-Qaeda members, because we have not seen the last of al-Qaeda. Pivot to the ISIL AUMF, which is the thing that's currently pending. Congress is wrestling with whether and how to give a fresh authorization of force specific, perhaps, to ISIL. I'd be interested in hearing your views on whether this is worth doing and what the necessary elements that, if it's to be done, must be included in there.
We haven't written anything about this.
No views on this. No. Give us the highlights only, and then I want to open it up to questions.
So I think it's likely, but who knows? I mean, every day it's changing. I think it's unlikely Congress will be able to agree on a bipartisan bill that the president will sign. But maybe, you never know. It might happen. I mean, the public has more support for it than the members of Congress do. And once they go home and start seeing the polls, maybe they'll be more amenable to working together on this. Would that be a terrible thing for our constitutional democracy if there were no new ISIL-specific AUMF? Well, I think the president thinks it would not be a good thing. It'd be better to have the legislative branch specifically on board with the president's military campaign.
And so that's what he proposed?
And the way he's running it. But this is, I mean, I just want to step back a little bit. This is not the kind of case that has precipitated constitutional crises in the past about the president's war powers, like Syria in 2013 did, where the president is unable to persuade the public, or at least one house of Congress, about a military campaign, and the deep constitutional question whether and in what circumstances the president can then act unilaterally. There's several members of Congress who have complained about the administration's legal theory for the campaign that they're using. There is not, as far as I know, not a single member of Congress, nor any significant constituency in the United States that thinks the president ought not to be engaged in the campaign against ISIL, or that thinks that because there's not authority, he was compelled by law to bring them home after 90 days, which is what the War Powers Act would require. So there is vast conspiracy that the president ought to be doing at least as much as he is now. The irony is there are many members of Congress who think he ought to be much more belligerent and doing much more against more actors and in more places. And that's the only real substantive debate that I think is going on.
But just to put the substantive debate in real terms, if one accepts the prevailing legal position offered by the administration, which is that everything it has done and is doing against ISIL in Iraq is authorized by U.S. law, some combination, and Syria, some combination of the 2001 AUMF, the 2002 AUMF, and I guess a modicum of the president's Article 2 self-defense authority. Basically, that's an argument that the right hand is already doing everything we need it to do. So then the question is, why do you need the left hand? And the problem, to my mind, the fundamental problem with the Obama administration's ISIL proposal is that it creates a left hand that doesn't talk about the right hand at all. Which is to say, right, it creates a left hand of authority without saying anything about how the two relate to each other.
No, but it's agreed. It would support a supersession provision.
The administration has said that, and yet they know how to write, and they curiously left one out. I mean, so there's, so I think the real question
there won't be any debate about that.
Who's going to propose it?
You can propose it. You have proposed it, Steve.
Right. Who's going to propose it? Who actually, is allowed to propose legislation in the United States?
Any member of Congress.
All I'm trying to say, guys, right, is that I think that there are two separate questions here, right? Is it a good move politically to have a statute specific to ISIL? And I think the answer to that is yes, for reasons that Marty alluded to and that I think are not that hard. Is it an important move legally? And I think it's actually a problematic move legally if all you're doing is creating an additional authority without refining them as compared to each other.
So as people probably know, one of the things that's in the administration's draft proposal is a prohibition on the deployment of ground forces in what's described as enduring offensive ground combat operations. I'm curious, setting aside the problematic uncertainty of what that entails, let's imagine they found a lengthier, more verbose way to actually
means X.
They spell out in a more persuasive way what they actually have in mind, because it's somewhat clear what they ultimately have in mind there. Does Congress have the power, constitutionally, can they forbid the president from employing ground forces while at the same time authorizing the use of force to destroy militarily an enemy? Marty, you've got several papers on the general topic. Apply it to this fact.
Yeah, I wrote about 300 pages on that, saying that Congress does have the authority, but and Steve's trying to encourage me to put it in Twitter form. So I'm just trying. So 3 characters, YES.
All right.
There you go.
Does anybody disagree?
Marco Rubio does, but he's wrong.
Okay. All right, so we have hogged the conversation. I'm sure there are many people who'd like to weigh in. So please raise your hand if you'd like to pitch questions. Otherwise, we'll just keep going. And do we have microphones? There's a microphone coming to you.
I never hear that at home, about needing a mic. I thought of it when I think Steve brought up the concept of the elephant in the room. I'd like to suggest another elephant might be there. Going back to the presidential campaign of 1988, the Willie Horton factor. I think maybe deep down in Congress, there's a fear of one of the worst things I could ever do is approve the release of these 122 Guantanamo prisoners, and they go ahead and commit a crime. I mean, the media would jump on that like crazy. I'm just throwing it out. I wonder what the panel thinks.
So, I mean, I think that the last people who would ever be blamed for a Guantanamo detainee being released and then engaging in any kind of criminal conduct afterwards is Congress. And I think Congress would be the first people to make sure that they were the last people who were blamed for that. It's worth stressing 2 points, though. First, there's a difference between Congress not releasing the detainees, and Congress affirmatively trying to make it impossible for the president to release the detainees. And it's the latter situation that we're in right now, not the former. And second, the statistics on recidivism are actually deeply disputed. And I think it was D.C. Circuit Judge Ginsburg who went out of his way to say in a case last year that the overall recidivism rate for Guantanamo detainees is far lower than ordinary criminals in our criminal justice system. So, I'm not sure that recidivism is anything other than a sort of a red flag to wave in front of the bull that is public opinion on the Guantanamo release issue.
The bigger problem for solving the Guantanamo mess eventually, with respect to the last, somewhere between 30 and 60 detainees, is finding other nations that will agree to take them. I mean, this really is a problem that was created without any obvious long-term solution. No end game in sight. And that,
Well, I will just say, as I have disagreed with Marty on this point in the past, I wholeheartedly disagree with Marty here. I think that's simply not true.
you think we
Now,
would be able to persuade other nations?
There are. I mean, the Yemenis can go home to Yemen. Now, we can all think that's a terrible idea. Yemen is not exactly a state right now. But that really doesn't have anything to do with an individual's right to be returned to his home country, regardless of what the political...
What's interesting with the change in government in Yemen, you might be right, in a way that they wouldn't have wanted these detainees at all 3 weeks ago. I don't know whether the new government would be eager to have these folks.
But that's also not true. The last two governments of Yemen were very express about their repeated requests for the repatriation of their own citizens, to the point that they were engaged in failed attempts to develop.
Our not sending them back, of course, isn't about whether they want them back. It's about whether we think they're going to make even a half-ass effort to keep them in prison when they're there.
I think it's both.
Or to monitor them. I mean, so again, I think we're conflating categories. So Marty's talking about the last group of detainees,
Right.
which is the group of individuals who at one point in time were labeled by the Obama administration as too dangerous to release and not possible to try. There's a first category, which is 55 detainees, I think as of yesterday, who have been cleared for transfer.
Yeah.
And so under the Obama administration's own view are not too dangerous to be released or transferred, most of whom are Yemeni, right? And so before we get to the thornier question of what to do about the last, the real worst of the worst, if I can borrow the horrible politicking of it for a second, there are plenty of detainees to provide remedies for long before we get to that potentially intractable conversation.
I do think we should focus on the hard group, not the ones who are cleared for transfer where there are these other obstacles. It just doesn't seem likely to me, but do you think that there is a home for these folks that's not the United States?
It's only intractable if you accept the premise that there is a legal basis to detain them without charge for, 15 years. That's not a premise that I accept.
Well, let's go with that premise
I don't
and-
think that, Andrea. Where are you going to put them?
They either can be released to their home countries or resettled in a third country. And I don't think it's true that there aren't countries that will take them. I mean, and even if someone's home country doesn't want to receive them, there are international legal questions about whether they can actually be turned away at the border. Now, there's a citizenship stripping movement that's going on around the world right now, and perhaps these people will be stripped of their own citizenship. But as a separate international legal matter, people generally have the right to be returned home to their own country. The country can then detain them under their own law, arrest them for something. Or I guess not give a plain clearance to land. But I don't think that's really other than for KSM, I don't think we're dealing with a lot of these issues where countries would literally block their borders and not allow their citizens to be returned.
It's an important question that an important empirical question that doesn't get enough discussion.
I just think the question, the idea that this is a problem has not been presented clearly anywhere. I have not heard the administration say, the problem is there are 50 people we want to detain only because there's no country for them to go to. That's not the argument. The argument has been...
Too dangerous. They're too dangerous.
It was extraordinarily difficult for Cliff Sloan and his colleagues and his predecessors to arrange transfers, even of those they've been able to transfer. This is not easy diplomatically. You may be right that it's not impossible, but it's not easy.
Okay, so let's go to another question. There's a hand up in the back left. Can we get a microphone over there? There we go.
Thank you all for this fascinating discussion. I want to push back on the idea that the worst of the worst are actually the ones who be transferred last. What about the Uyghurs in China, where we have a legal obligation to make sure that they are not executed or further imprisoned in China? What do we do with them?
So the Uyghurs were, after a whole lot of very messy litigation, the Uyghurs, who were the first detainees to prevail in a CSRT appeal to the D.C. Circuit, were ultimately all transferred out of Guantanamo. There are no more Uyghurs at Guantanamo. I believe they were transferred to a combination of Palau and Slovakia?
El Salvador.
And El Salvador, right. So, you know, that I would never say Guantanamo success story in a sentence. Bermuda, right. That's not a success story, but it's at least one problem that is thankfully in the past.
Okay. Next question, please. Down here in the front, Mike Schmidt.
Mike Schmidt, that's you.
It is. I need a microphone.
Oh.
So I'd like to ask a question that ties into all of the earlier panels, and it has to do with.
Because you still have 36 questions left from the last round.
It's going to be for you, and it has to do with Bobby's hypothetical in which a state engages al-Shabaab and there's an armed conflict now. So, Bobby, I think that's right. I agree with that, but only once the intensity threshold is crossed. So it's not just bombing al-Shabaab, it's bombing them a lot. But then, Andrea, this is why I wanted to ask you the question. It surprised me when you jumped on and you used the example of Boko Haram in Nigeria, that the United States could start a conflict with them. Because we have to remember that these are non-international armed conflicts, and they're not international armed conflicts, it's a different type of conflict in terms of initiating them. Does this mean that Human Rights Watch now buys into the position?
Say no.
No, it's
You
very,
can tell
very,
from the tone of your voice that the answer is
no, it's
no.
very important because this was an issue that Andrew brought up. The ICRC is doing work. Yelena Page, who's probably one of the best IHL lawyers in the world, is working on this now. And it's the issue of the geography of war and whether or not you can have a war outside the confines of the state. The ICRC has said it has to be in the state and it can spill over. Others, I'm one of them, and apparently Bobby's another, says, no, that's not true. It's all about who's involved and whether you cross the intensity threshold in a NIAC. So in your hypothetical, that is outside the borders of the United States. And assuming that there's sufficient organization and sufficient intensity, would Human Rights say that the Human Rights Watch say that there's a conflict between the United States and Boko Haram taking place in Nigeria? Because that would appear to be contrary to what the ICRC is saying.
Well, that would be hugely fact-specific. I mean, what role was Boko Haram playing? What was the Nigerian government doing at the time?
Why would that matter at all? The issue is whether or not there's a conflict between the United States and Boko Haram, a conflict that is non-international in character, and it's occurring outside the confines of the United States. So long as there's sufficient intensity and the group is deemed to be sufficiently organized, how is it fact-specific?
Well, what we have said in Yemen, specifically with the conflict with AQAP, is that although the U.S. government does not say it, it is likely that the U.S. is a co-belligerent, essentially a co-belligerent, alongside the Yemeni government in its internal armed conflict against AQAP. So that would be the most likely scenario where if Nigeria, which, depending on where or when, may be engaged in an armed conflict with Boko Haram, if the United States were to operate alongside it, it might join that existing armed conflict.
What if they were not? My question, I mean, you're doing good here, but my question is, you're not answering the question. The question is, let's assume we're not talking about a NIAC with the host state in which the United States is asked by the host state to come in and assist them. We're talking about a conflict with a state. Let's not use Nigeria, let's use state A, state B. Can you have a conflict, a NIAC, outside the territory of the state
With
that's
no
engaging?
state involvement? No, I don't think so. There is no global war against Al Qaeda. It's the same argument. That has not changed. We don't believe that there was an armed conflict throughout the world against Al Qaeda.
Hypothetical, it would require a request from Nigeria for
Well, my
assistance.
hypothetical was Al Shabaab. Steve brought up Boko Haram.
Wait, Mike, can I just back though? Wait, can we go back to Afghanistan circa September 2001? Right. So it seems to me it could be either side of the coin, which is to say, is the actual government of the country either requesting the United States participation as a co-belligerent, or are they on the other side, such that there are at least some elements that look more like an IAC, right? Which I think is not a preposterous description of what was
But I
true.
think what Mike is positing is there's a host state that's worried about a potential terrorist threat that has not attacked yet, but they're building steam.
But then how would that meet duration and intensity?
Because
When
they're
the
going to
United
ask the
States
United
is
States to
bombing.
just go bomb the hell out of them, creating the duration and intensity. Would that be okay? because you have the consent of the state, so you don't have a charter problem.
Well, I mean, I don't opine on the use ad bellum issues. I think what Mike was saying, well, at some point, would there be an armed conflict?
Not a use ad bellum
Would we have-
issue.
would
It's
there
a
be an armed
very, very
conflict between them?
simple issue in IHL, and it is currently the hot topic. It is currently the hot topic. The ICRC is engaged. A lot of us are engaged in this, and it's an incredibly important topic. The question is very, very simple.
So what
Can
Ashley,
you
I
have a
think we're
NIAC
not there.
outside the borders of
It
the
hasn't.
state?
so what Ashley Deek suggests in her very good article about consent is that in that case, Nigeria would be violating its own human rights obligations by asking us to do that, and that maybe international law ought to develop to prohibit us from doing what Nigeria can't ask us to do.
All right, we need to get more people involved, and all the way in the back.
I hope I responded to that.
You're becoming the track star. Question, the AUMF for Afghanistan was interpreted by the Bush administration as one of the bases for authorizing warrantless surveillance, including of people in the United States. There was another basis, Article 2. Can this AUMF be similarly misinterpreted, probably not by the Obama administration, but by another administration?
To authorize what exactly?
To authorize surveillance that targets a person in the U.S. without complying with the requirements of the Foreign Intelligence Surveillance Act.
I think the new statute expressly, go ahead.
What about the new stat? I mean, what in the current bill says no?
No, I think the underlying surveillance law, didn't Congress repeat the FISA language that this is the exclusive authority and
In 2511-2.
and the AUMF argument that was made by the Bush administration was, I want to say roundly repudiated because I repudiated it, but
How about soundly repudiated?
soundly repudiated. I mean, I don't think most people thought that was a very good argument.
But posit an undisputed ISIS, member who was found in the United States, right? I mean, is it that much of a stretch to think that in that context, this or a future administration might say that it's that FISA doesn't apply and FISA exclusivity doesn't apply because it's an exercise of military force to conduct surveillance of that individual?
Which is why I said at the outset, that's my biggest concern about an AUMF. Any law can be abused, any administration can ignore the law. But we have seen this happen with the 2001 AUMF, so I think we should be particularly concerned that it might happen again with the future AUMF. Not just surveillance, but all sorts of human rights abuses.
Other questions? Yes, right there. And then we'll come back.
I just want to express maybe what Mike was having trouble getting across, because I know he has sometimes trouble debating and this sort of thing. I think what he was trying to say is, and I'll speak for ICRC here, what we were dealing with was a situation of you've got an active battlefield, you've got a NIAC that's going on that battlefield. Everybody agrees, this is Tadich, that the armed conflict applies to the territory of that battlefield. ICRC has agreed that spillover from that conflict is still a NIAC situation. The question that's being asked is whether when you have a single individual or a small group of individuals who leave that battlefield and go to a peaceful country X, again, let's talk about Northwest Africa, they've gone back home, they're on leave. The question is whether you can use lethal force in the first resort against that person or a small group of persons, or whether that is in fact a law enforcement situation in the quotation marks, a self-defense type of mode. And I think that, from our perspective, as ICRC, we're trying to avoid this global battlefield. And there are different ways you can argue that legally. You can say that that IHL is territorially bound, that there are many references to territory. I'm not sure I buy all those arguments. I think right now it's in the lurch. It's a bit in limbo, this whole discussion. It's a question of state practice now and how it's going to develop. But I do think as a matter of policy, it's a bad idea to have a global battlefield. But bearing in mind what Mike brought up very legitimately, which is that this is a situation that's still bound by the use ad bellum. So you still have a body of law which keeps you from going into another country. They're two separate issues. But I don't think the second
They
issue
are, but
has
I think
been
the use ad
answered by
bellum,
yourself.
use ad bellum is doing some of the human rights work, right? So that you can't just go in if there really is an option, and this was in the last panel and this one. It's why there really never was the prospect of global war on terror, because In Paris, the French would, just as in Seattle, the French would have the capability of handling it through law enforcement means, the way we do with terrorists that we find in the United States. We would ask them to do so, and presumably they would agree to do so. The problems have arisen in these so-called ungovernable spaces where capture operations are, in some respect, infeasible. The host state can't do it or doesn't have the political or military or police capacity to do it or the will to do it, and in which capture operations might result in far greater casualties than the use of force. And the question then, and I think you're right, it's a hard one, is in those situations where there's consent, I'm worried because there would no longer be proportionality and necessity constraints. Where there's not consent, even so, what is the alternative? What is the state that's being attacked by that nation, by that non-state group? What are they supposed to do exactly? And you and I had this discussion yesterday, and you thought, well, they should go in, or you were suggesting, I don't want to put it, right? The United States should go in with ground forces, as we did with respect to bin Laden, rather than using lethal force in the first instance. Is one possibility, notwithstanding the fact that that nation, the host nation, is telling us, you better not invade our sovereignty with ground forces or they'll be held to pay for it.
But proportionality and necessity still apply even if there's consent.
I'm not sure that's right. This is what worries me.
But moreover, just to respond directly to that, I think this is an area where Human Rights Watch differs from the U.S. government in our view of the operation of international human rights law at all times. So international human rights law says that there can't be any arbitrary deprivation of life. In an armed conflict, we're looking at IHL to determine what is arbitrary. In a Paris cafe, what is arbitrary may be very, very different, and we will be looking to human rights law and law enforcement standards at that time.
And Bobby actually suggested this in his article about Alaki. Right. That is there any really good reason to think that in that scenario, the one that all of us are worried about, that this would violate human rights norms to use lethal force where there's no other option of dealing with the threat? Now you might say there is another option. You get some, Navy SEALs to go in and do a ground operation.
There's a feasibility constraint.
With all of that entails, but every nation would be different. It's very... Yeah. They tend to be lethal, but they could do an operation that prefers capture, for instance. Right. That's what Andrew was suggesting.
Well, and this kind of ties back into, to bring it back to Mike and the process, the DPH process. And one piece of it, which y'all mentioned earlier, was the introduction of the idea, Nils's idea about necessity of attempting capture. But that's part of what's going on, right? This is all reflecting a policy interest in trying to grope towards a situation where you can't shoot first, where lethal force isn't the first option. All right, we have time at least for one more. Dick, right there, and then we'll come down here for a final one. So make it short enough for one more to come.
Yeah, I just wanted to ask, what do you all think, particularly you, Bobby, you've worked on habeas issues. What are the prospects of habeas resolving the problem of enduring detainees and interpreting the Kennedy three-pronged test as the time limit expiring on law of war detention?
I'll defer to Steve on this, at least initially.
I'll just take a shot. I think in the short term the prospects are slim, and I think that it's a linear. The longer time goes on, the greater the prospects become. In that regard, I think. Erwin mentioned earlier today the shift in the composition of the D.C. Circuit, which I realize is a very technical, nerdy Fed courts thing to bring up. But the D.C. Circuit that was deciding the Guantanamo cases 5-6 years ago, right after Boumediene, was majority. I think it was 6-3 conservative Republican appointees. The D.C. Circuit that's hearing these cases is now 7-4 Democratic appointees, 4 of whom were appointed by President Obama. So that's not to say that overnight we're going to see a shift in the D.C. Circuit's jurisprudence. I don't think that's likely at all. But Dick, as time goes on, and especially as questions of first impression get up to the D.C. Circuit, I think we're going to see some different rulings out of this D.C. Circuit, and I think the military commissions are going to be where we see that first.
Well, now, let me just add real quick that that change that Steve just described probably will also then precipitate the return of the Supreme Court to this issue, and unless its personnel have changed a lot, I think you'll then see sort of the reverse of.
I want to suggest in response to Dick's question that it depends a lot on what Andrea was saying.
Yeah.
If the courts think that ordering the release of someone that there are no options of where to release them except into the domestic United States, no court of appeals in the United States is going to order that in the next
Vitas.
5 to 7 years.
That's right.
If, on the other hand, it becomes publicly understood that there really are options, maybe not perfect ones, but options of transfer to other nations with some risk involved, the courts would be much more amenable to starting to push in Justice O'Connor's direction.
I think that's right.
And I promise this gentleman could get the last word.
Just a follow-on, a little bit more narrow. That small portion of the population that have been determined to be al-Qaeda and that are intelligence-based detainees, in other words, you don't have prosecutable evidence either in military commissions or in the civilian court. What processes do as we go forward in the, forever construct? And is that, I think you may have answered it, maybe that's an issue that should go to the Supreme Court.
So they're already, it did go to the Supreme Court. So they are already receiving something called periodic review boards. And these, well, habeas too, but the whole point of the
for
last
the annual,
was habeas isn't going to do anything.
Okay.
Sorry, Bobby.
No, you're good.
I was going to say, so the periodic review boards have actually had some, depending on how you believe the success or failures, depending on your perspective, in taking folks who are in the category of too dangerous to be transferred and moving them into the category of transferable. And there's actually just another decision yesterday. So I think, there's process to at least whittle down that category. I, for one, am skeptical that the PRB process is ever going to whittle that down to zero.
Oh, it never will.
What it's going to do is it's going to get it down. This is why Marty said somewhere between 30 and 60. When you throw in the folks who have been slated for military commission trials that might never happen, that's the big question, is how large is the group once the PRBs are done, once the military commissions have run their course or been stopped in their tracks. It's
very interesting. Somewhere in the last 2 weeks, an administration official used the word, what was it, several to describe the end, rather than several dozen.
I think that was wishful thinking.
Well, thank you very much. This has really been a terrific panel, and we'll be able to carry on conversations.
Okay. I hope that was.
Yeah, we planned that very well.
Great.